I am Roxanne.
I forgot to do.
I am Roxanne Jen, and this is our wonderful fellow attorney, Karishma Patel.
Good afternoon, everyone.
Fabulous. All right, so this goes right into it. We have a fantastic presentation for you today because we are actually going to be talking about the matters of the heart. So the example that Karishma and Morgan know that I always use is, what if one day I am diagnosed with a incapacity sort of medical diagnosis, or because I live in San Mateo, I'm walking in downtown San Mateo, as I often do on the weekends with my family, and all of a sudden I get hit by a car. And the good thing is that I didn't die, but I'm in a coma, so I'm incapacitated. So what can I have in place, Karishma, to allow my loved ones to make healthcare decisions for me?
You should have an advanced healthcare directive in place.
You mean like this one here?
A completed, yes, like the one we have in front of us or something similar.
Fantastic. Can you tell us a little bit about this particular form?
Sure. So an advanced healthcare directive is a document that yourself, so if I'm completing an advanced healthcare directive, I would choose the agents that I would like to nominate to advocate for me on my behalf in the event I'm unable to do so. And I would also give them some type of authority, whether I'm limiting them or allowing them to make all medical decisions on my behalf in the event that I'm unable to do so.
So, Karishma, if I fill out this advanced healthcare directive and I sign it, does it mean I can never change it again?
No, you can change your advanced healthcare directive multiple times, as many times as you wish. You just need to make sure it's fully completed. So you appoint agents, you sign it, and you get it witnessed or notarized. And it needs to be dated.
So if I put this together, I mean, is this where the document that I would use to articulate wishes like life support wishes and things like that?
This is where you would articulate your life support wishes. That would be one of the choices. Our healthcare directive gives you a pretty basic choice of whether you would want life support or not want life support, but this is where you make that decision.
Perfect. Shall we look at this document in detail?
Let's do so.
All right. So as Karishma mentioned earlier, the power of attorney for healthcare, the first thing that we're going to want to do in the event of incapacity, we want to have people that we love and trust to step in and make healthcare decisions on our behalf. So we call them agents. So we, the ones creating the document, the ones executing the document, we are the principals. And then the agents are going to be the folks who step into our place to make our healthcare decisions for us if we cannot make those decisions for ourselves. So in this example here, this particular individual has named John Doe as his first agent. If not John, then we've got Sue. And so we always add backups because we never know what life might bring us. And we don't know if the individuals we're nominating might themselves either be unavailable or perhaps incapacitated themselves. So we always add backups to backups. And as you can see on this particular form, you can even designate a third person. That is typically the average number of agents that we see our clients nominating because we like to have those backups for those worst case scenarios. Here on this form, in this part 1, the principal is authorizing his agent to make all healthcare decisions. So you'll see at the very bottom, it's highlighted just for the purposes of illustration, so we can see it a little bit better. But we are authorizing John Doe to first make all healthcare decisions for the principal in the event that the principal cannot make his own decisions. Then we move on.
Me too.
And here we go to part, it's kind of hard to see. It's still part
so
1.
The top of part 1, it just talks about when your healthcare agent's authority becomes effective. So there is right below the yellow highlight a blank couple of lines. If you select that, then you're allowing your agent to have power effective immediately. Otherwise, if you do not select the box on 1.3, it's only effective when you become incapacitated. And so you're basically, your agent has the obligation and you're trusting them obviously to act in your best interest, whether they know or even if they do not know all of your wishes. Part 2 is going to be instructions for healthcare. So this is where we touched on life support. So you would make a selection under A or B as to whether you would want the choice to prolong life or not to prolong life regarding end of life decisions. And so this would be in an instance where you have an irreversible condition or something that's incurable, and to a degree, and the doctors say with a degree of medical certainty that the risks do not outweigh the benefits of the treatment and you're likely to pass within a reasonably short period of time. What would you want in such a situation? So would you want all the measures and life support, or would you just want some comfort care?
And, Krishma, in my experience with clients, and I'm sure this is the same for you, it's a really personal choice with regard to end of life decisions, isn't it?
It is. It's a very personal choice.
And do folks ever have do they ask you, is there a right answer?
Yeah, they do ask that, and it comes down to it's their choice. Or when there's couples that are in the room together, the spouses have differing choices, and they say, "Oh, you selected that. Oh, I selected this. Why'd you select that?" So it's very personal, but
very personal.
Good to know what others would want or what your spouse would want.
Absolutely. Absolutely. And before we leave this page, I just wanted to point out that in part 1, under 1.5, there is the authority continues even after the individual passes away. And I used to just kind of glaze over this section, but it's actually very important because it has to do with the disposition of the principal's remains upon death, because you still want somebody to have authority over your body, your remains, so that it can be, have services provided by a funeral home, a mortuary, and of course, burial or cremation decisions. So you would most of the time still want your agent to be able to make those types of decisions even upon death. Okay.
And 2.2 at the bottom, before we go to the next slide, it talks about relief from pain. So here we typically will leave this blank unless the principal individual wants specific medication withheld. Otherwise, as long as you leave it blank, all of the pain relief will be provided to you.
Perfect. Thank you so much, Karishma. So I guess, the question that we have to think about is what kind of person do we want to nominate as an agent? And we have a quick movie clip to share with everyone. The video quality is not great, but it's really the narrative that we want you to pay attention to. Let's see if this will work for us.
Excuse me. It is after 10. Give my daughter the paint shop, please. Mrs. Greenway, I was going to... Oh, good. Go ahead. Just a few minutes. Well, please, it's after 10. It's after 10. I don't see why she has to have this pain. Man, it's not my patient. It's time for a shot. You understand? Do something. All she had to do is hold on until 10. Thank you very much. Thank you. Excuse me. It is after.
So the reason we show that clip is you want to choose somebody who is going to advocate for your healthcare decisions in the treatment of your medical conditions. So in that video, that mom was really advocating for her daughter to have that timely pain medication administered. Whether or not it was that nurse's own patient, it didn't matter. Mom was going to be there for her daughter and make sure her daughter received that medical treatment. And so you want to nominate individuals in your life, whether they're family members or friends, to make those types of medical decisions and advocate for you. Okay. All right. So this, continuing on, I believe this is still part 2. If you have additional wishes, you can add additional instructions here, but you want to be really, really clear so you don't accidentally provide inconsistent instructions. Okay. And Karishma, how about part 3?
Yeah. So part 3 is, it talks about donations of organs at death. And so this would be if an individual is a donor or would like to donate organs or any viable tissue or body parts upon their passing, they would then fill out this section. And then if they would like to limit it, so where you see the highlighted section, it says strike any of the following you do not want to apply. So if I'm going to select that I'm going to donate organs and I do not want it going for research, I would cross out research, and then it would apply that they could use them for transplant therapy or education if anything is useful.
Perfect. And this is my own personal quirk, but the only part of my body that I probably would not want to donate, and this is just me, I think it's my eyes. I think it's conceptually, it's very difficult for me to wrap my head around that. It's very selfish of me, I understand, but yeah, that's the only limitation I think I would have. Moving on to part 4, primary physician. So we all likely have a primary physician that we see on a regular basis, and we're getting, annual checkups and just general medical care. But typically we are leaving this section blank for our clients simply because primary physicians are ever changing. And so rather than having to update your documents every single time you change your primary physician, as the physicians are retiring, or perhaps they move or change practices, or maybe you just go and find a new physician, without having to update your documents time and time again, we leave this section blank just so it will still work for you if your physician does in fact change. Okay, very good. And so now I believe we're going to move on to part 5 in terms of how to execute this document.
Yes. So part 5 is going to be the execution. So 5.1 states that a copy of the original executed form has the same effect as an original. And typically what we do is we encourage our clients to actually share copies of their healthcare directive with their agents, whether it's a PDF copy or a photocopy of the original. That way, if anything does happen, their healthcare agents have the copies that they have been provided to act upon it when their agency comes up. 5.2 talks about signature. So here I mentioned earlier that you need it fully, you want your healthcare directive fully executed. So it would be dated, you need to sign it, and it's going to be notarized or witnessed by 2 disinterested people who are not named in your healthcare directive or any of your documents.
Beautiful, beautiful. And I think I should have.
Witnesses on the next page.
Yeah, there they are. All right.
So 5.3, this was where I talked about the witnesses. And then if there is an individual who is completing the healthcare directive and they are in a skilled nursing facility or somewhere that provides services and basic care to them, then they do need also a signature of the patient advocate or an ombudsman.
Beautiful. And though this is a general overview of the Advanced Healthcare Directive that we go through with our clients and we review and make sure that our clients have in place as part of a comprehensive estate planning package. If you'd like to learn more about the Advanced Healthcare Directives that we use, you can simply visit our website. I believe there's a downloadable version of this on our website at www.mcdlawyers.net. Fabulous. And I think with that, do we have any questions, Morgan?
We do. I will go ahead and start with the first one that I see. This one says, does an advanced healthcare directive provide the authorization for release of protected health information?
That is an excellent question. We at our office actually have that as a separate document. We call it the HIPAA release. As most folks know, the health privacy laws here in the United States and in California are very, very strict. So we actually need that release of medical information, and we just draft it as a separate document. We've seen it in the past where it's one and the same as the Advanced Healthcare Directive, but we separated this document out, the HIPAA release, because perhaps you want more people in your life to receive the medical information, but only a very select few to make medical decisions for you. So for that reason, we have them separately.
Next question, what defines incapacitated in an advanced healthcare directive?
Good question. Would you like to take that one?
So incapacity is going to be, well, in the healthcare directive, it's going to be if it's defined by a physician. So a physician would sign a declaration stating that the individual lacks capacity to manage their day-to-day or to make their own medical decisions. Also, typically, if you have an estate plan, so at our firm, obviously we do comprehensive trust-based estate plans. So your trust will actually also define how incapacity is going to be determined. It could be a physician standard. Some trusts and individuals, they may have a disability panel. So it just depends. If it's the trust, then that's going to define it. Otherwise, if it's just a standalone document, it's typically going to be a doctor.
Beautiful.
Next question. Let's see. Is an advanced healthcare directive durable?
Yes, it lasts. So upon, once it becomes effective, once an advanced healthcare directive becomes effective, which is typically upon the incapacity of a principal, once it becomes effective, it continues to be a valid document until death. Upon death, you can no longer make medical decisions on behalf of that person, but it does also continue with regard to the disposition of remains, as long as that part does not specifically terminate those powers.
Okay, next, difference between power of attorney and advanced healthcare directive. Is there any advantage or disadvantage over the other?
That's a good question. So
Roxanne, I'll let you answer. The question is the difference between a health power of attorney and advanced medical directive. So there is no difference. They are one and the same document. It's just that they have two different ways of being addressed. I think back in the day or during earlier times, I don't know if people still prepare them because I've only ever prepared advanced healthcare directives, but a power of attorney for healthcare and a healthcare directive is the same thing.
I think in different states, they're called different things. So here in California, the most common name for a power of attorney for healthcare is going to be called the Advanced Healthcare Directive.
Okay, last one. What do you do if a nurse says a patient's conditions do not fall under an advanced medical directive? This person says, we just had a situation where a nurse said a delusionary patient does not qualify for the designated person in the AMD to take over calling the shots on medical care.
I guess that's kind of a who's the quote unquote delusional person? Is that the person who's having medical decisions made on behalf of, or is that the person that's trying to make the decisions? So oftentimes, if somebody is declared incapacitated by a physician, then the agent will have the power and should have the power to make decisions on behalf of that incapacitated person, so long as there is a valid advanced healthcare directive in place. Thank you.
I believe that was our last question. Fantastic.
And I do have a page here with regard to our upcoming information.
Yes, thanks, Roxanne. This is just a reminder to everyone, if you are not already subscribed to our newsletter, to please subscribe. That's where we put out all of our exciting McDowall Cotter law firm information and what's going on with the firm, vlog information, articles, etc., all that good stuff. As well as our social media. Please follow McDowall Cotter on all social media. We're on Facebook, Twitter, TikTok, Instagram, and of course LinkedIn. So please go ahead and follow us for more information on McDowall Cotter.
Fantastic. And that's all due to our social media maven, Morgan here. So thank you very much. Thank you everyone for attending, and we'll see you next time.
Thank you, everyone.
Bye, everyone.